Pleasure to welcome you all to our 2025 Partnership Seminar. We have seen a significant uptick in investigations within the last couple of years. These have a capacity to throw up a number of difficult, practical and legal questions. Whilst there are obvious overlaps with investigations in the employment context, there are a string of important differences in the partnership and LLP arena. So we thought it would be a good subject for today. And we've assembled an all-star, or at least two-star panel. Our first speaker is Carol Davis KC. She specialises in complex, high-value and reputationally sensitive disputes. She has developed a market-leading, I think it's fair to say, reputation as an independent investigator. Chambers and Partners 2026 reports that Carol is extremely impressive as an independent expert investigator, dealing with the most complex bet-the-company investigations with rigour and clarity. She is addressing today the particularly thorny issues of confidentiality in partner and LLP member investigations. David Reade KC is our second speaker. He's been in Silk for 19 years. He has appeared in leading authorities across the employment, commercial and partnership sphere. His wider expertise will need no introduction, but what I can simply say from a partnership perspective is that his innate aptitude for it and for the most challenging cases will be well known to many of you. Of the numerous directory accolades he has received, and it took me some time to weed through these over the years, the one that most struck me was the description of him as tenacious, clear, polished and empathetic, and I think that is entirely accurate. His approachability is particularly appreciated by everyone, by clients, by other practitioners with difficult questions or novel issues. And he is discussing today a novel issue that has been thrown up in the aftermath of the Privy Council's decision in the Jardine case, which is a particularly important case for us all. I will be taking up the themes that Carol and David have explored, and I'll be setting them in the context of the litigation of exit disputes. Because, of course, these investigations can lead to everyone living happily ever after, but they can lead quite simply to expulsions. And I think that what we're going to be doing in my talk is to try and cover the different fora where such disputes litigate. So as we know, they can go to arbitration, to the High Court or to tribunals. And what I'm going to be teasing out is how is it that you can prevent publicity or prevent disclosure in those different fora, and when is it likely that material will come out, and how do the practical dynamics play out? So without further ado, I shall pass over to Carol.
Thank you, James. Not being as sprightly as the 19-year Silk, David Reade, that took me a while to walk over, but I will try and speed up, and we're looking at confidentiality. And as James said, we've seen a marked increase in partner misconduct investigations over the years. And there are several reasons why that might be so. Societal change following the Me Too movement and a hardening attitude to misconduct in the workplace generally. Generational shifts with associates and junior staff perhaps being less willing to tolerate sexual harassment or discriminatory conduct silently than may previously have been the case, and also legal and regulatory pressures. Firms, of course, now are obligated to take reasonable steps to prevent sexual harassment, and most regulators are making clear that misconduct allegations shouldn't be hushed up through the use of non-disclosure agreements. And of course, many have lowered the threshold for self-reporting allegations of misconduct. It's also fair to say that partner misconduct investigations can take quite a long time to complete, commonly now months rather than weeks, with complex allegations and complicated evidence deriving from multiple sources. One or other of the parties involved or witnesses can become unwell and unable to participate for a time, And increasingly, firms are looking to external investigators, shameless self-plug, when allegations of partner misconduct are involved. And the capacity of external investigators, as helpful as we are, can be harder to manage. Another issue that I think we're seeing is that constitutional documentation was put in place many years earlier, when it might not have been contemplated that the partnership might have to conduct the sorts of investigations into partner misconduct that are now prevalent. So we're all seeing and doing a lot more. In today's talk, I'm going to look at why confidentiality matters during these investigations, how much information the accused partner is entitled to see both during the investigation and after, including looking at what the firm can legitimately withhold even if a subject access request is made. I'm then going to briefly touch on additional duties under the SRA's rules and guidance, including self-reporting obligations, before finishing with some practical tips. There are three key reasons why confidentiality matters in investigations, and firstly, integrity. Internal investigations are an essential aspect of risk management, helping partnerships ensure that they meet their legal, regulatory, and employment obligations. And poorly managed investigations risk failing properly to identify and manage underlying risks or control weaknesses, and can lead not just to repeated incidents, but also serious regulatory breaches. And managing confidentiality is key to the successful conduct and management of the investigation. Any investigation, of course, must be conducted in a way that limits leaks, prevents collusion, and protects the evidence base. Secondly, witness protection. Coming forward as a complainant or being asked to participate as a witness can be an immensely stressful thing. Almost invariably, the individual is going to be concerned about retaliation and their repercussions at work if they participate. So having in place proper protocols in relation to confidentiality is key, as is being able to explain clearly and accurately what will happen to a person's evidence once they've given it. Because candid evidence is crucial, and you simply won't get it if people are unclear how their evidence is going to be used and who's going to see it. It's really important, however, not to overpromise in relation to confidentiality. It's simply not possible to guarantee absolute confidentiality, and as an investigator, you must not fall into the trap of doing so. For example, it may be impossible to investigate certain allegations without putting them to an individual in sufficient detail that they can respond. There may also be a regulator overseeing the investigation or waiting in the wings, who may require disclosure of the investigation report and its supporting documentation. And of course, it's possible that in due course there's litigation that arises out of the investigation and or any resulting disciplinary action or expulsion, and non-privileged material is going to be disclosable. Of course, if the complainant is a whistleblower or a victim of a sexual offence who's made a complaint to the police, then you're also going to have to think about whether the individual is entitled to anonymity and how the confidentiality protocols will facilitate that. And finally, there's the obvious point that allegations against a partner can be destabilizing to a firm, both internally, if the fact of an investigation becomes widely known, and externally, given that allegations of misconduct and associated rumours, particularly related to the conduct of a senior partner, can really rock client confidence. So what is it that a partner is entitled to see? The starting point before commencing any investigation is to look at the partnership deed or the LLP agreement. And in an ideal world, that will specify how investigations are to be run, what the accused will be shown, whether reports are going to be shared in full or summary form, and how confidentiality is managed. Now, that's the ideal world, isn't it? In cases where partnership deeds or LLP agreements are not quite as all singing and dancing as one might like, and I think that's more the rule, the default position are the provisions of the Partnership Act 1980 and the LLP Regulations 2001. Section 24(9) of the Partnership Act gives partners the right to have access to and inspect the partnership books. Now, this is complemented, of course, by Section 28, which is often described as part of the partner's duty of good faith or fiduciary duty, and that provides that partners are bound to render true accounts and full information of all things affecting the partnership to any partner or his legal representatives. In the case of LLPs, Section 24 of the Partnership Act is mirrored by Regulation 7.7, which provides the right to inspect the books and records of the LLP, and Section 28 of the Partnership Act is mirrored by Regulation 7.8, which provides that each member shall render true accounts and full information of all things affecting the LLP to any member or his legal representative. Now, of course, in LLPs, members' duties largely come from the LLP agreement, and there's no automatic fiduciary duty between members in the same way as there is in general partnerships. However, applying the principle from Braganza and BP Shipping, courts may be prepared to imply terms into the LLP agreement requiring powers to be exercised in good faith, rationally, and not arbitrarily. Thus, in an LLP investigation, even if the agreement gives the management board wide powers, those powers are still constrained by the duty of good faith or the proper purpose principle. The very polished David Reade is going to consider those provisions in a little bit more detail in the context of privileged material. But for present purposes, in the context of confidentiality, the following principles apply. And the term books and records is given a broad interpretation, and it's generally understood to mean the formal financial and business records of the partnerships. The courts have tended to take the view that partners are entitled to see the records necessary for them to exercise their rights and duties as partners, but not automatically every working paper. The fiduciary obligation to provide one another with full information of all things affecting the partnership is broad, but it's not unlimited, and it doesn't override any confidentiality owed to third parties, nor does it mean that one partner under investigation is entitled to see all internal investigation notes either during the course of an investigation or at its end. And it may be entirely legitimate for a partnership to withhold, for example, sensitive witness interviews or other working papers, including internal deliberations, if disclosure would harm the integrity of the investigation or the breach of another's rights. Of course, it doesn't mean that the partnership can conceal the case entirely from the accused, because that would be bad faith. In the case of LLPs, the entitlement to all things affecting the LLP is again wide, but yet again it is not unlimited. A member's right to access information during an investigation has to be balanced against fairness and the need for confidentiality and the importance of preserving the integrity of the investigation. So, while a partnership may be able to withhold some material from a partner under investigation, it can't run a wholly secret process. And even if the partnership deed allows for a wide discretion in handling investigations, the partnership must act honestly and for the benefit of the partnership and avoid disciplining for or expelling for ulterior motives. And courts are really going to scrutinise processes that appear unfair, arbitrary, or driven by factional motives. And therefore, to withstand challenge, the accused partner should be told the essentials of the case and given a fair chance to respond. And that usually means being provided with a clear statement of the allegations, the key documents and evidence that will be relied upon, so there must be no ambush with hidden evidence, and also given an opportunity to make representations and to respond. And after the investigation, assuming, of course, that the partnership deed or LLP agreement doesn't specify to the contrary, the usual practice will be to provide a reasoned outcome letter, but not to provide the full investigation report, witness interviews, internal deliberations, management discussions, or privileged legal advice. Of course, in respect of any privileged material, it's important to remember that the breadth of CPR disclosure obligations in any litigation that may follow might mean that those documents are disclosable. So care really should always be taken during any investigation in relation to what is recorded in writing and what all those involved in an investigation are told or promised about confidentiality. One particularly irritating wheeze is that partners and LLP members often use data protection law to try and gain access to investigation files and the final report. And of course, under Article 15 of the GDPR, individuals have a right to obtain a copy of their personal data. And it's important to recognise that there aren't any ways of contracting out of data rights with data subjects or avoiding them altogether. However, there are a series of exemptions that apply to data rights, including the right of access, and those, at least insofar as they're relevant to investigations, are set out in Schedule 2 of the Data Protection Act 2018. Now, of course, it's not a good idea simply to routinely rely on exemptions or apply them in a blanket fashion. Rather, each exemption must be considered on a case-by-case basis. And I've set out on this slide the key exemptions that tend to be most relevant in the context of internal investigations in partnerships. And perhaps the most useful is the paragraph 16 third-party data exemption, which provides that the data controller, and that includes any external investigator, is not obliged to disclose information to a data subject to the extent that doing so would involve disclosing information which relates to another, which would identify that other person, unless the individual has consented to the disclosure or it's reasonable to disclose the information without consent. And in determining whether it's reasonable to disclose the information without consent, the controller must have regard to all the relevant circumstances, including the type of information that would be disclosed, any duty of confidentiality owed to the other individual. And pausing there for a moment, if you're dealing with a witness, generally speaking, the witness will have been told they are being interviewed as part of a confidential investigation, thereby creating a duty of confidentiality. Also, any steps taken by the controller with a view to seeking consent, whether the individual is capable of giving consent, and any express refusal. And when considering whether the information in question relates to another individual, one has to consider not just whether the information itself identifies the source of the information, but whether or not the source of the information would be identified because of any other information which the controller reasonably believes the data subject is likely to possess or obtain. And if third-party data is so mixed with an individual's personal data, as indeed it often will be in investigation documents, that may mean that it's justified to withhold the documentation in its entirety rather than attempting to redact. The right to access also does not apply to personal data that consists of information in relation to which a claim for legal professional privilege could be maintained in legal proceedings, or information in respect of which a duty of confidentiality is owed by a professional legal advisor to a client of the advisor. With respect to the second limb, and again this is possibly a shameless self-plug for external investigators, whilst there's no guidance from the ICO about the extent of this duty of confidentiality, If one looks at the purpose of the exemption, it's, I think, reasonably clear, or at least common sense would suggest, that in this context, an external investigator, solicitor or counsel engaged to conduct an investigation is likely to be considered a legal advisor. And of course, any information or data that they hold is held subject to their professional and regulatory duty of confidence, and therefore you might be able to rely on paragraph 19 exemption to withhold data. The right of access also doesn't apply to personal data processed for the purposes of management forecasting or management planning in relation to a business or activity. So perhaps one could rely on this exemption to withhold disclosure of all or parts of board papers discussing whether or not to expel a partner. The exemption, however, only applies to the extent that complying with the access request would prejudice the conduct of the business or activity. And finally, the right of access doesn't apply to personal data that consists of records of the intentions of the controller in relation to any negotiations with the data subject. And it might be possible to rely on that exemption to withhold disclosure of all or part of emails or documents about an exit package. Again, the exemption only applies to the extent that complying with the access request would be likely to prejudice negotiations with that individual. Of course, if relying on an exemption, the partnership would be wise to justify and document its reasons for relying on the exemption. Don't forget, if you're dealing with law firms, that regulatory duties override confidentiality. And by way of example, paragraph 3 of the Code of Conduct for Firms requires firms promptly to report to the SRA any facts or matters believed to amount to a serious breach of the SRA's rules and obligations, and paragraph 7 of the Code of Conduct for Individuals requires them to do the same individually. And if you are conducting investigations, do have a read of the SRA's guidance on conducting internal investigations. So just to end with some practical tips, and I think the important thing to remember is that confidentiality in investigations is a balance and not an absolute. And what one wants to achieve in any investigation is a disciplined and documented process, one that withholds what can be withheld lawfully, but discloses enough to ensure fairness and legal and regulatory compliance. And one of the most important things, of course, is to plan appropriately before starting the investigation. So check the constitutional documentation, see what, if anything, the partnership deed or LLP agreement provides by way of express powers of investigation in relation to the disclosure to partners and with regards to any suspension or expulsion mechanics, something that the equally polished James is going to look at shortly. When preparing the terms of reference, decide early on whether you're going to involve external counsel. There's an argument to say not only does it support independence, it makes it a little bit easier to control confidentiality during the course of investigation as opposed to when it's handled by a firm internally. And when you're defining the scope of the terms of reference, consider and document the confidentiality protocols, including reporting lines that are going to apply. Who is going to have access to witness interviews, for example, and other evidence generated by the investigation? And give careful thought as to how any investigation documentation is going to be stored. I would always say that it is sensible to store confidential and privileged material separately and clearly label it as confidential and privileged. Of course, the label is not determinative, but it certainly does give you pause for thought when you're considering whether or not to share a document. It's also sensible to keep factual and evidential documents separate from legal advice and deliberation documents. And during the investigation, be careful how you manage confidentiality. For example, limiting access to material. So identify the core team on a need-to-know access basis. Use secure platforms for document storage and keep an access log. And of course, remind everyone involved in the investigation, including witnesses, that the investigation is confidential. In relation to witnesses, as I said, it's important not to overpromise, but equally important to be transparent and accurate. And remember to give the partner under investigation the essentials of the case, including the allegations, the time frame, and the key evidence. And they must be given enough information to understand the case against them and to respond. But of course, to the extent that witness evidence needs to be provided at all, it should be redacted and anonymised as necessary. And of course, during the investigation, care must be taken to avoid disclosing privileged advice. And it's important really to document your thinking. So keep an audit trail and a log of disclosure or redaction decisions. And I think that's over now to David and privilege.
Thank you very much, Carol. I think I've had two observations about being in silk for 19 years, and lest the ageist proceedings are commenced, I'd like to make it clear that I was a childhood silk, and that was an honour bestowed on me at a very early age. The second apology I have to give is an occupational health risk of being a barrister is losing your voice having been in court all day shouting at a judge. And I seem to spend all day shouting at a judge. Whether or not she listened, it remains to be seen, but I did at least spend the day shouting at her. Anyway, so I apologise for my voice in that respect. I'm going to look at partnership and legal professional privilege, which has some practical issues. We need to talk about some practical solutions, but we need to start off at some conceptual concepts and recognise that there are actually, rather surprisingly, some murky, not entirely clearly resolved issues in areas where you might have hoped the law was a little bit clearer. And to do that, we just need to identify some key concepts. In relation to privilege, of course, there are two types of privilege. We don't need to go back extensively over that. There's legal advice privilege and litigation privilege. Litigation privilege being the particular form of privilege when litigation is in reasonable contemplation or litigation has started. Litigation privilege will always be a narrow area subset, because essentially you've got, beyond there being the prospect of a mere dispute, you've got the prospect of that dispute occasioning litigation. Really what we're focused on here is legal advice privilege. And we're talking about legal advice privilege where partners or members might have taken legal advice, and the issue is whether or not they can maintain legal advice privilege against their fellow partners or members. And that may be true both in the context of whether they are members or partners, but also in litigation afterwards. Because if the partnership has broken up or the membership is in dispute and there is litigation, and as a specific disclosure request in that particular context, a former partner or member seeks disclosure of advice that might have been taken that isn't caught by litigation privilege, in other words, any dispute they had yet to reach the stage of crystallising into contemplated proceedings, there's a question then about whether or not litigation privilege, legal advice privilege can be asserted against them. Now, as I say, bits of murky waters in some ways, because you have to drag back some of the law back to the 19th century, and you see old authorities, and occasionally when you look closely at these things, the foundation for things is not quite as clear-cut as one might have thought. One of the things that that historically in the textbooks was drawn a parallel with in relation to members and partners was something called the shareholder rule. And the shareholder rule has had a recent outing. In a case called Jardine Strategic Limited and Oasis Investments, I need to obviously make the observation that Oasis Investments won and therefore didn't look back in anger, unlike the other Oasis. They get worse, of course. This case looks specifically at the concept of the shareholder rule. Now, what's the shareholder rule? In many ways, rather a surprising rule, as it was understood. Basically, it meant that if you had litigation brought by a shareholder against a company, legal advice privilege could not be maintained against that shareholder in litigation unless it was litigation privilege. So if the company had taken any advice, legal advice about shareholder rights, shareholder structures, or anything of that nature, even though it might have been subject to legal advice privilege against the world, it couldn't be asserted against a shareholder. So if I wanted to litigate against ICI with my one share, if in fact there was legal advice that ICI had in relation to that, I could, if it was relevant, seek specific disclosure. When you looked at the origins of this, you went right back to the 19th century, and the main case, looking at that old law, was a case called Woodhouse and Woodhouse. Now, of course, it does have a relevance if you've got a limited, a general partner who's a company in a limited partnership, or you've got a partnership where one of the entities is a limited company. One of the arguments that people had for why this rule should exist was the idea of there being a joint interest. We'll come back to that. Anyway, in March, the Privy Council looked at this for the first time in many, many decades and said that it was the emperor with no clothes. There was no actual legal basis for this principle, long shadowed since 110 years. And they effectively concluded that although there were parallels in the old case law with trustees and beneficiaries, what had happened is, back to Solomon and Solomon, at a point in the 19th century, we recognised that companies had a separate legal existence and shareholders therefore had no rights against the company's entitlement to instruct. So they ripped up the concept of the shareholder rule. And although it was actually a Bermudan appeal, they exercised their power to say that they were stating the law in relation to England and Wales, as well as in relation to Bermuda. Now, one of the arguments that have been run to say why, well, you could still hold on to this principle, was to say that all of the shareholders in a company had a common interest, and as they had a common interest, when the company acted or sought advice, there was a common interest between the company and its shareholders. And the Privy Council said, well, actually, we can see lots of cases where all the shareholders are at odds with one another, and it's actually impossible to assume that just because you're a shareholder, your relationship is always aligned. But they do say, of course, there are relationships where people's interests are always aligned, for example, partners. Brackets, as we know, not always quite true. But they said there's a common interest between partners and therefore they share legal advice or the right to access. Now, the Privy Council expressly said they weren't going to look in detail at the law of joint interest privilege, but we need to look at it just in looking at how partnerships might work in terms of legal advice. But even before we get there, we need a step back. In many respects, the most common problem. If you have a situation of a joint retainer, so not joint interest, but a joint retainer, in other words, more than one person has instructed the lawyer, then the position is clear. You can't assert advice privilege against the other person who co-instructed with you. So if you've got a traditional 1890 partnership where one partner enters into a contract on behalf of all the other partners, if they trot off and get legal advice in their capacity as a partner, it's a joint instruction for everybody. As it's a joint instruction for everybody, it's impossible to assert legal advice privilege against your other partners. In proceedings, you'd be entitled to get specific disclosure of that particular advice. And there's a case called the Shahira that makes it clear that you can't maintain such confidence. And also there are problems about the advice you've got as well, because if one person thought it was advantageous to waive privilege about the advice they got, to say, oh, well, look, we were told X, Y, and Z, and that might explain to the world why we were doing things, you can't waive joint retainer privilege unless everyone agrees to that particular waiver. So it's quite a cumbersome thing. We'll come back to this. However, if you've got an LLP or a general partner in a limited partnership, of course, and they are the entity that's instructed, quite separately themselves, there may be no joint retainer because the LLP has a separate legal entity and the general partner may be instructing in a separate sole capacity. But that gets us to joint interest. Joint interest is another problem area, not particularly well resolved. Joint interest privilege says if you've got people whose interests are aligned, if one person goes off and gets legal advice, even if they haven't got it for everybody, if it's legal advice about the area where interests are aligned, they can't withhold privilege of advice against other people. And that is what the Privy Council were alluding to about the relationship between partners. Forget the joint instruction. If you've got old-style partners, because in principle their relationship is aligned with each other, if one partner gets legal advice about the way that the partnership works, in principle they can't maintain privilege of advice against the other partners, unless that is a dispute has emerged so that their interests are no longer aligned. That seems to be a little bit wider than litigation privilege. Has a dispute emerged to the point where people's interests are not aligned? And as I say, you might think a lot of this law will be clear. In fact, you have to go to the wonderful Nova Scotia law reports to find any case that actually looks at the concept of when joint interest might have come asunder. And even that isn't actually a case about partnerships. So, common joint interest might be said to exist between the partners, old-style partnership, limited partnership. But then we come onto another ground, and this is arguably, on one level, the trumper. And that is, Carol's already touched it as a topic, rights of account and inspection under the Partnership Act. We've got three elements to this we need to be alive to. There's Section 28 of the Partnership Act, a partner, old-style partnership duty to give true account, the fiduciary account of affairs. Section 29, subparagraph 9, partnership rights of access to inspect books of account, brackets, but not actually to copy them, only to inspect them. And if you've got a limited partnership, those rights are applied by Section 6 of the Limited Partnerships Act 1907. And if you look at an LLP, the default rules for an LLP replicate Section 24 and Section 28 in the default rules. Now, what does books of account or record embrace? And again, you might think there'd be lots of clarity about what fell in that particular context, and actually we don't find a lot other than some first instance decided cases. In fact, I think both were decided by the same judge. And as Carol identified, there's a broad interpretation placed upon books. This was actually a case, and indeed the other case, about a limited partnership. So it was about the general partner in a limited partnership and limited partners seeking disclosure about advice it was taken, and disclosure in litigation. And the issue was whether or not the general partner could maintain advice privilege against the limited partners. And that turned in part on the question of, was this part of the books and records? And what we find is that the court took a very broad interpretation, as Carol has identified, of what might fall within the books of records. Now, this was mainly concerned with financial issues. It wasn't specifically concerned with legal advice. But what the court said was a rough functional rule is that if, and here, as I say, it was a limited partnership, so they were looking at the general partner and the manager. If the advice is retained or the material relates to documents to record, establish or determine the rights or adjust the rights of the parties between each other, then it's a book or document or record which relates to the affairs of the partnership and which can be inspected. So that looks pretty broad and sufficiently broad enough to say that if you got advice that you maintained on the books and records of LLP, limited partnership or traditional partnership, and that general advice concerned how the relationships of the partners worked or what the structure of things was, that would be material that should fall within the records that could be inspected. And that would be particularly compounded if it had been paid for by the LLP or partnership out of partnership it funds itself. Because as the court said, if you've got someone who's acting in a fiduciary duty and they've paid for it using funds of a fiduciary nature, it must be the inevitable conclusion that you start off that they did it for the purpose of the affairs of the partnership and therefore it forms part of the books and records. I included a second bit of Ferreira which deals with further interpretation of books and records, but the core bit is the first. So where does that take us, all this uncertainty in some respects? Well, the first thing to say is that it's absolutely clear that with an LLP, those default rules about the right to inspect books and records and account can be modified. That's what the rules say. You can change them by agreement. In the limited partnership case of inversiones, the court at first instance noted that limited partnerships could modify by special agreement access. I don't actually find where the authority is for that, but they seem to recognise there was one. And in the Court of Appeal, and as I say, you're scratching around for some of this stuff, in an unreported case, which the transcript isn't even available of as far as I can see, and all there is a note in the New Law Journal, the Court of Appeal in passing said that they thought the 1890 Partnership Act could have an agreement that modified books and records and access to rights. So all of that seems to suggest that you could address specific agreement. Now, I'm going to come back to that. What happens if you haven't got specific agreement and you are in a position where there is a nurturing dispute that you can't say is reasonably contemplating litigation? Well, practically, the first thing to say is that any retainer for legal advice should be advice given to individual partners or members seeking that particular advice. I should say that may not be the end of the story when we look at it, but in principle, it should be their advice and they instruct, not the LLP, not the partnership. And it should not be treated as a firm expense. Now, I find that's one of those bits of advice that people's colour drops from the face when they quite expected that they were going to be paying, someone else would be paying for it, including the person they were having a disagreement with. I think it is theoretically possible that somebody might be reimbursed later on for expenses that they'd incurred at an earlier stage, but obviously that shouldn't be agreed in advance, because if you've agreed it in advance that you will be reimbursed, then effectively all you're doing is deferring your agency. It's possible that if because of the structure of joint interest, it's possible, as I say, that even if someone has paid for it themselves and got separate advice, because unless it can be said that a dispute had arisen to the point of their interest departing, it might be argued that they can still be required to disclose the advice that they got, because of the existence of a common interest between them and their fellow members or LLP, fellow members or partners at the time they took the advice. Probably that's not so likely to happen because most people would take contentious advice in this nature because of the very fact that a dispute has arisen. But what can you do beyond that? Well, obviously, and some people do this, you could, in the LLP agreement, limited partnership agreement, or the partnership agreement, if those cases are right about general partnership and limited partnerships, it's absolutely the law for LLPs, have an express agreement that says that those in a managerial or executive role could take legal advice, pay for it out of the firm's funds, yet maintain confidentiality against other members. But I'm not sure that trumps litigation, because the problem is with such an agreement, you're not making it litigation privileged, you are merely creating a ring fence of confidentiality. That's all it is, it's a ring fence of confidentiality. And if there was litigation subsequently, it seems to me there's a strong argument for a former partner or member to say, whatever the agreement says about you having been entitled to take that advice and keep it confidential, that's just confidentiality, and a court can override it and make specific disclosure. So my note of caution is, if you build these sorts of clauses into LLP agreements or partnership agreements, don't enjoy a great sense of comfort that that's going to mean that the advice that falls in it is always going to be held to be confidential against a former member or partner in litigation. There may always be merit in the entirely separate instruction by one specific group of partners, because this may not provide a complete solution. With that, and my tender 19 years, I'm going over there to give James the floor.
So what I'm going to do is look at how all of this plays out in litigation. Because as David has just explored in his last slide, there is a significant difference between what an LLP or a partnership can refuse to provide in correspondence, can argue about with the Information Commissioner, often sometime after the material events, and what actually happens when you're in court or arbitration. So I'm going to begin with some context, because the key touchstone for disclosure and for testimony remains relevance. And you can only understand the way these disputes typically arise if you have some understanding of the nature of the disputes and the common issues arising in those disputes. As many, if not most of you, will know the relevant law very well, I'm going to deal with that fast. And I'm then going to focus on the hard edges. So non-disclosure of complaint or complainant details to partners, what is going to happen in different types of litigation, non-disclosure of information to partners voting on expulsion. It's mainly an issue of fairness, but it can also become, and this is something that people can forget, if you have your litigation and disclosure comes out in the course of that litigation, everyone always thinks about, oh, what about the disclosure going to the aggrieved partner, the aggrieved LLP member? But of course, there can come quite an interesting moment when members of an LLP who have voted for an expulsion suddenly discover that there are all sorts of documents or allegations or matters of which they were unaware. And that can catch people out, so I'm going to talk about that very briefly. I'm going to talk then quite a bit about different fora. So we all know that these disputes can litigate in arbitration, in tribunal and the High Court. What is less commonly appreciated is that the rules not only differ, but also they differ very materially in terms of when these crunch issues crop up. And that's an important point, because very, very many partnership disputes are all about when is the case going to settle. And timing your settlement or your push for settlement can be quite important and informed by that. And then I'm going to talk about privileged disputes in practice, not least because I've done one of them very recently. And then I'm going to talk about publicity in the true sense of that word. So I'm now going to turn to a whistle-stop tour of the law. I believe we now put these up online, so I should give a disclaimer and say that this is not all the law relating to partnership exit disputes, just for anyone who wanted to unreasonably to rely on it. But just going to the business end, Section 25 of the 1890 Act says there's no power to expel unless conferred by agreement. Then you have the duty of good faith as between partners. The venerable case of Blissett and Daniel shows that applies to a decision to exercise the power either of expulsion or of dissolution of a partnership. The shortest view of a very complicated issue is that an expulsion which is in bad faith or out with the scope of an expulsion partner is a nullity. So the partnership would have to start again and the partner would be treated as if they had remained a partner throughout. Then you have issues of construction of partnership deeds and implied terms. Now I'm going to, as I said, I'm sandwiching this section, so I'm going to deal with implied terms in the context of LLPs. Virtually the same principles apply. Now the LLPs, I'd just like to draw out three really basic points that always need to be borne in mind. The first is that the LLP agreement is all about the mutual rights and duties of an LLP and its members, and that agreement is given primacy by Section 5.1 of the Act. And so contract rules. Now there are a second point that follows from that, is that if you look at the 1890 Partnership Act, it contains all sorts of rules about what will happen by default in various circumstances. And those sections have been the subject of repeated litigation over more than a century. By contrast, if you actually go to the regulations, it's absolutely correct, as Carol and David have both picked up, that they echo bits of the Partnership Act or replicate it. But a huge amount is not covered in the LLP regulations at all. So really, the field of play is primarily a contractual one. And then the final point is that because this is a contract that cannot be repudiated, you cannot have a constructive dismissal, and that's very important in the context of investigations. So whereas a senior employee may say, after a few sessions, obviously not with any investigators we may know, I've had enough, it's too much, I'm resigning, you've undermined my relationship of trust and confidence with you. It's very difficult to do that in an LLP context. It's not impossible. There's a case called Wilson's and Roberts Solicitors in the Wilson Solicitors and Roberts in the Court of Appeal, which shows that in certain types of discrimination and whistleblowing claim, you can have something that feels a bit like a constructive dismissal, but it is not a proper constructive dismissal. But again, when we come to expulsion, it's very simple. Same principle as the Partnership Act. You need an express power. So then you come on to the question of construction. And this is particularly important in the case of LLP members because there is no general duty of good faith as between members. That is established by the Barthélemy case. And so the debates you often end up practically having are about, is there an implied duty of good faith as between members? And what are the other implied terms that are going to be relevant to the particular circumstance you find yourself in? And that is the battleground in expulsion disputes, at least in my experience. And then if we get all the way to an unfair, an unlawful expulsion, there is then this debate in LLP law as to whether you have a claim for damages at large, i.e. all of the money I would ever have made if I had remained a partnership of your very impressive firm, or whether the firm can turn around and say, well, actually, we should apply Johnson and Unisys by analogy. We should cap your recovery at the level of time we could have lawfully given you notice for. And that is a debate which hasn't been resolved. The current editors of Lindley and Banks have very trenchant views that there should not be any such cap. They say it would be a license to wrongdoers, which I have to say is true. So what is the key implied term? Well, it's already been mentioned. It's Braganza and BP Shipping, not an LLP case, but applied now in several LLP decisions. And it's the duty to take into account relevant considerations, leave out of account irrelevant ones, and reach a decision which is objectively reasonable. It reminds us all of the Wednesbury Picture House, which some of us may have had the pleasure of addressing in law school. And this is a decision which can catch a lot of people out, because although the people in this room will be familiar with it, very often you can have partners who decide that they are, for example, lawyers. They don't need to take external legal advice. They've got a very clear power that if 2/3 of them vote to kick someone out, that's that. And they press on. And then the case arrives with you and you say, oh, well, this is going to be interesting. So what is this implied term about procedure, if any? Now, here we have one of my favourite book quotes. I keep updating it. The book keeps updating, but I think it remains the same. The role, if any, of procedural justice in the exercise of a power to expel or compulsorily retire a member is not wholly clear. So there you go. So a common question people come to us with is, well, what does this actually mean? And I think that Carol has touched on the key issues here. I think there is going to be a right to respond. And what one needs to do is to look at the question of what form does this right take. And despite its complete oddity in terms of subject matter, the Dimmock case is very important because it's not a pure employment case. It's an association case. There are obvious parallels with the partnership and LLP arena. And what's said there is that there was an implied term that Ms. Dimmock would be treated fairly in relation to her termination. This, of course, is the minute you utter the word fairness in the context of partnership law, you can have some practitioners become rather concerned it feels a bit employmenty, but that's what was found. And in particular, that she would be informed of the complaints or concerns in sufficient detail to enable her to respond to them, and be given a reasonable opportunity to depend. That applies not only to the substance of the complaints or concerns, but also to the question whether they justified the sanction of termination of membership. And I think that provides quite a bold statement of the kind of implied terms that you can see. And that is the statement that is going potentially to condition the scope of disclosure obligations. It is potentially going to condition the proper focus of witness testimony. And one of the key issues that you've got to ask about sensitive information, because obviously everyone will say, if you only ask them for this, they're not going to want to give it to you, they'll settle the case. But the key touchstone remains relevance. And one final point I would make about all of these decisions is you've got to go back. Do you remember earlier I said I will deal with an issue of construction? There is a fundamental difference between terms that say, if in the reasonable opinion of the management committee, the other partners, whoever it may be, the partner has committed gross misconduct, they may be expelled. That's an opinion-based test. And so there what you're looking at is what information did the other partners have, what did they consider, what opportunity did they give the individual in question to reply. Yeah? Those are the sort of key touchstone issues. But then there are many deeds refer to if the partner is guilty of serious misconduct. And in that question, you're something much closer to what we would call common law wrongful dismissal. And that will have a significant impact because if someone has made a complaint that they have been treated in such and such a way by a partner, then there is the potential that the court is going to have to decide as a fact whether that happened. And that, of course, again, has a dramatic effect on the scope of witness evidence disclosure. So those are the legal issues. Now let's go to the question of what happens in practice. So let's assume that this investigation that we have been thinking about leads to an expulsion. The aggrieved member, let's assume it's an LLP member, brings an arbitration claim because, of course, a lot of LLPDs have these. Now, the first thing to understand about arbitration is it's one of its major selling points is it's private. Now, that is obviously relevant as regards the public, third parties, and so on. But it has a knock-on effect on how the arbitral tribunal itself is going to conduct its procedures. Because its assumption is that as everything is in private, there is no compelling reason to have further levels of confidentiality within the arbitration. And this is reflected in a number of rules. And I've gone directly to the question about witnesses, because I think that this is something that there can be a misconception that in arbitration, it's not quite the same as the High Court. But the LCIA rules, very influential, a lot of arbitrations are governed by them. They say that the default position is that you can make a request to attend for oral questioning, and if that attendance is not forthcoming, an adverse inference may be drawn. And the question of weight is very, very difficult in those circumstances. And again, the default position is that a party has the right to question someone who gives oral testimony at a hearing. So that's where you get to in terms of these crucial issues about complainant evidence in some kinds of case. Now, at the antecedent stage of evidence and disclosure, the most influential rules are probably the IBA rules, the international rules. I think they date from 2020, the most recent version. One of the key points, again, which catches people out, is that the way it works is you make a request for production, i.e. disclosure, and then you get objections to that. Crucially, privacy, personal privacy and so on, is not an objection that is even listed by the IBA rules. Yeah? And again, when it comes to testimony, it's the same thing. Any other party may question a witness. And then the question comes, because I have seen this happen, what happens if the partnership says, well, this is all so difficult that we're just not going to bring this individual along, or we're just not going to disclose the documents. And again, here it's different from the High Court, because you're not going to get an arbitral tribunal saying you're in contempt, report yourself to the tipstaff. That's not going to happen. What instead you're dealing with is inferences being drawn by the tribunal. And this is very, very common in arbitration. Arbitrators are very used to drawing inferences. And the key point is this. You as a partner litigating against them cannot be guaranteed that the LLP is going to produce all of the incriminating interview notes. You can't be guaranteed that someone is going to come along to give evidence. But conversely, if you are representing the firm, the LLP, and you fail to produce this material, the risk that you run is that a very easy way out for an arbitral panel or a sole arbitrator is to say, well, it's all very interesting, but they simply haven't led the evidence, and so the claim succeeds. And that is where it happens at the sharp end, which is why sometimes when you hear about some of these surprising results in arbitrations, that's the kind of dynamic that can be in play. Now, in the High Court, if we move over there, it's a very different debate. The first issue that typically comes up is disclosure. In the business and property courts, there are these disclosure models. Those of you who are familiar with them will gain nothing from me talking about them, and those of you who don't know them probably won't want a tour of them either. But suffice it to say that there is now a menu system, and people get very excited about which model, which extended disclosure model, etc. The blindingly obvious point is, if you're acting for the member, what you need to do is to make sure that you go for a model which is going to give you the information that you want. If you then get to the stage of specific disclosure applications, the basic touchstone is relevance and importance of the documents. But then you come into the question of, is there a countervailing factor? Is there a reason to refuse disclosure? The most important is privilege. Now, David has dealt with privilege disputes. Can I simply make some practical points? First, normally those are resolved at an interim hearing with witness statement evidence rather than live testimony from solicitors talking about why something is or is not privileged. It is worth bearing in mind that you can have these disputes resolved at trial. That can, for example, happen if there are disputes about who said what at a particular meeting, relevant to the question of whether there was a dispute. So I was dealing with one recently where there was a lot of argument on the law, but the judge's point was, well, I'm going to need to hear evidence about this. So there is a facility for the court to determine these at trial. And then, important also to remember about privilege, that courts can become very windy if they think that what privilege is being used for is simply to throw a veil over all sorts of documents and information that they would expect to receive or to know about. So if you have a situation where the only thing that is said not to be privileged is a letter saying, we write to terminate your membership of the LLP, then of course the court is going to be saying, well, hang on, what's happened beforehand? So that's the practicalities of privilege disputes. Now, there is a new issue which I have been asked about a bit recently, and some of you may have had, which is that one of the basic issues was about secrecy of the court file. Now, the impetus used to be on parties, third parties, the public, newspapers, not news agents, to make applications for the court file. But over the summer, Lady Justice Cockrell, as she now is, has explained a new move to default publicity for various documents, and so most documents. And so the impetus is going to be on parties to apply to restrict access to the court file. And that is going to mirror the position that we have for hearings, i.e. that the default position is open justice, and if not, you have to make an application. Now, the relevance of this could be very significant. This is not as yet in the Chancery Division. They're starting off in the Commercial Court and the London Commercial Court, I believe. But clearly, if you have a situation where the minute you launch a set of proceedings claiming that you've been wrongly expelled, the entirety of your pleadings could be public domain, that will have a very significant practical effect on the litigation of these disputes and clearly is going to push more people into arbitration clauses. In terms of practicalities dealing with the system as it is, my advice to a lot of people is many of these issues, you can spend hours in the white book. Sometimes, not that we always like picking up the phone to our opposition, it's not something that we do every day, but you'd be amazed at how much can be resolved on a pragmatic basis through things like confidentiality clubs, use of ciphers. And in many of these cases, it's not really going to be attractive for either party to be having a heroic battle in court about this. So that's why you see so many deals done. What you cannot do deals about are naming people if the Sexual Offences Amendment Act applies. Be alert to this decision in Ajao, where after having heard the evidence, the Employment Tribunal concluded that the allegations were all untrue and that lies had been told, and therefore that there was a change of circumstances permitting the naming of Mr. I believe he was, Ajao. Now, that was decided by the EAT on appeal, but the same principles would apply anywhere, and it's very relevant indeed. We then have common law anonymity and ECHR rights. The truth is, I've had some excellent advice from specialist silks over the years. You tend to end up having a so-called balancing exercise. And one of the problems about balancing exercises is that you never know how an individual judge is going to decide how that balance should be struck in a particular case. So there is, frankly, an area of considerable uncertainty about it. Now, we've seen that we're overlapping with employment tribunal work with the Ajao case, but can I simply make a final and important point about the High Court cases, which is there's a case called Dring, which I haven't mentioned. And Dring was about, after the trial, parties seeking access, it was asbestos litigation, seeking access to all the information, all the court papers. Now, these applications are starting to creep into the partnership sphere. And one of the things is that if you reach your brilliant settlement or, you have your resounding triumph in a judgment, that isn't the end of the matter. You need to think very carefully about how do we clear up this case as best we can to keep as much of this out of the public domain as we can, and that will involve making an application. And the key point about High Court litigation, even more so with this move on the disclosure pilot, is if you want to keep it out of the public domain, you have to do something. So that's the simple advice. Employment tribunal litigation. The first point, can I just begin with the practical point at the end? Until you get to an open hearing, the situation as things stand today is that none of these documents are public. And that is very, very relevant tactically. It's very relevant practically, given not least the lead times for employment tribunal cases. So on a pragmatic basis, it might be said that in the employment tribunal, you tend to have quite a long time during which you could settle your case in private. And that is a very relevant consideration. If we actually look at the sharp edges of ET procedure, it's very similar. You end up on disclosure in a position very similar to the CPR 31.6. Virgin Atlantic is an EAT case applying that. Old authority, Mr. Justice Langstaff in the EAT, how do you determine relevance? You go to the pleadings. Redaction. Now here there is a discrepancy between the practice of very frequent redaction of employment tribunal bundles and the law as set out by Hancock and Promontoria Chestnut Limited in the Court of Appeal, which explains how you are meant to go about resolving disputes over redaction. Privilege applications, certainly when I've done them, they've been dealt with by a separate judge. I had a case a couple of years ago where they in fact insisted on removing all the relevant pages from the tribunal judge, from the panel, and having a separate judge in. Rule 49, this has been a touchstone of litigation, and in its previous guise as Rule 50. The three cases, Millicom, XY and AB, and FVJ. The reality is that those authorities make it difficult to secure wide-ranging restrictions on publicity. And it is a challenging issue, particularly when you are dealing with third parties. Because most of the authorities focus on, the claimant wants to keep this in or to keep this out, or the respondent. Much more difficult for third parties. And I've actually seen some quite sad cases about third parties where the reality was neither of the actual parties had any real interest in third-party rights. And I have to say, not that it's my job to feel sorry for people, but I have felt sorry for people who find themselves with, the Daily Mail at the back of the tribunal and all sorts of things coming out. So there we go. Witness statements and skeleton arguments. The Guardian News and Media case shows that even in tribunal, and even though there is often an open question as to whether the tribunal itself has these documents or whether they are long lost, the parties can be obliged to provide these to the media or via the medium of a tribunal. So it's very relevant. And these judgments are now, in principle, publicly available. Now, the question that I began with is, what comes out and how can you stop it? And the answer to this is very simple. Unless you fit within one of the exceptions, one of the rules, one of the types of application that I have described, your dispute is going to come out. And one of the key questions you have to consider whether you're representing the member or the partnership is, if it does come out, who is going to be the bigger loser? And what do I want to come out and when? And what I would suggest is that although this is a lot of the issues we've discussed in a sense are quite technical today, I think this should play quite importantly into litigation strategy. Because once you're aware of the potential ramifications, either for the individual or the partnership or both, of this material coming out or not coming out, I think that has a very significant impact on how things are run. Thank you very much.